Hey everyone, Zach DeLorno here with my law partner, Logan Greenberg, and today we're going to go over the topic of independent administration and what that means in regards to a succession. And I'll just turn to you, Logan. What exactly is independent administration?
Right. So the way it used to work is if you were going to be the person in charge of wrapping up the affairs of the estate, so if you were going to get the will and you were going to actually distribute property according to the will, you had to go and get court approval for everything you were going to do. So if you were going to transfer funds, distribute property, buy or sell property of the estate, so sell a house that the estate owns, you had to go ask the court for permission. And many years ago, the Louisiana legislature realized that that was extremely time consuming and very costly. And so to make it easier on people, they gave people the option to do what's called an independent administration. And all that meant was from now on, if somebody is granted the authority to be an independent administrator, they don't have to seek court approval to do anything they need to do in the administrative process. They essentially can do whatever they want to do to wrap up the affairs of the estate. And Zach, am I missing anything here?
No, I think you're spot on. Only thing I would add is, and when Logan's referring to you, he's referring to the actual succession representative. So when you open a succession, there's either a will that names someone as the executor or someone is appointed as the administrator. Executor, administrator, whoever that person is, there's a representative of the estate. And that is the person that has the authority to make these decisions. And if they can make it independently without the court, generally it's just a more efficient process. That executor has to bring back a final accounting to the court. So I don't want to come off as like a free-ranging process, but they don't have to make every single decision. They don't need the actual court approval. They're entrusted with that power. And one thing that I know we've seen on some of the wills we've done recently too, or some of the successions we've done recently, we see that the word independent was left out in someone's will. So someone is named as an executor, but it doesn't use the word, I name so-and-so to be an independent executor.
And generally speaking, we see that mostly when people were creating these wills before the law changed.
That's right.
And so a lot of the lawyers just didn't know that that was going to be an option one day.
That's exactly right. So if a will was created in the 80s, generally it doesn't have that word. That word alone can save a lot of time and hassle for your family. So if you've done a will a long time ago, it might be this could be a good opportunity if you're watching this video now to just check and see if that word's in there and update it and make sure whoever's named as your executor, they're named as an independent executor so that the succession can proceed in an independent fashion. And that way you're not constantly making the representative go back to the court. Anything else?
Nope, I think that covers it. Very important to have, very important to ease the administrative burden on a succession. But if you have any questions about it or want to ask us about your will or creating a new one, please feel free to reach out.